Kia ora koutou katoa. This is the third video in a series on treaty principles, a guide to key readings. In the Court of Appeal, New Zealand Māori Council versus the Attorney General, aka the Lands Case, 1987. Delivered 29 June 1987, this case has defined Crown Māori relations ever since. In particular, the case introduced the term partnership into our treaty discourse. Wittgenstein once quipped that a new word is like a fresh seed sown on the ground of the discussion. That word in 1987 was partnership. It is difficult to find another contemporary word in our legal political discourse that has so influenced our common life in Aotearoa. The way Māori scholars such as Hugh Kāwhuru welcome this concept, see the last video, illustrates how significant it was in the late 1980s. And since then, it has taken on a life of its own. The context of the court's judgment was the fourth Labour government's corporatisation of several government departments on the grounds that they were being run inefficiently, of course. The government planned to transfer its lands and forest assets into a state-owned enterprise structure. Approximately 10 million hectares of land were proposed for transfer to the new SOEs, State-owned enterprises, including the new Land Corp and Forest Corp. Now, Māori feared that once inside that structure, at least a step or two removed from direct Crown or government control, the land would not be available to treaty claimants in the event the Waitangi Tribunal recommended that lands be returned. Remember, the historical claims process had hardly commenced at this time, and only a portion of historic claims had been filed. This became a critical issue. In a dramatic series of legal and parliamentary proceedings and manoeuvrings, the Waitangi Tribunal heard an urgent application on the SOE bill as it passed through Parliament. The bill was amended mid-process, crucially adding Section 27, which provided protections for land claims already filed with the Tribunal, and even more crucially adding Section 9, which stated, "Nothing in this Act shall permit the Crown to act in a manner that is inconsistent with the principles of the Treaty of Waitangi." Now notice as a sidebar that practically no one was talking about Te Tiriti or Waitangi in the late 1980s. Māori iwi groups were still concerned these provisions of the new Act did not cover the situation of claims yet to be filed, of which there turned out to be many. So they took a High Court application judicially reviewing the Crown's actions, and the court regarded the case as so important that it moved proceedings immediately into the Court of Appeal, our highest court at that time, apart from the London-based Privy Council. This was a dramatic, defining series of legal moves. A who's who of Māoridom appeared in the Court of Appeal, including Graham Latimer, leading the case for the New Zealand Māori Council, Dame Whina Cooper, Sir James Henare, and Mason Jury, to name only a few. Now, the court held, in simple terms, that the government could not progress with its plans to transfer large quantities of state assets without providing for a procedure to protect these lands for future successful Waitangi Tribunal claimants. This procedure was, in the event, put in place through negotiation, including a scheme to direct into a trust the interest from Crown Forest Licence rentals, funds that would, as it turned out, critically support Waitangi Tribunal research and the hearings process. The Tribunal Historic Claims process took place over the next several decades and is still ongoing, while the bulk of the available Crown Forest assets have already been returned to Māori through treaty settlements. It's important to remember this case was 37 years ago. Many New Zealanders alive today were not alive then. We should remember that it was this case that introduced the concept of partnership into the public discussion on the Treaty of Waitangi. So on the case itself, a full bench of the Court of Appeal heard the case, 5 judges. The principal of the court, Justice Cooke, delivered the first judgment, and 4 separate judgments followed, slightly different in emphasis, but largely to the same effect. Most judges discuss the partnership concept. It is apparent that they were drawing this concept from the private law of partnership, that is, in which business partners, for example, are obliged to deal with each other reasonably and in good faith. Thus, the treaty relationship between Crown and iwi Māori was seen by the court as akin to a private law partnership. Cooke was a brilliant judge and was later promoted to the Privy Council in London to become Lord Cooke of Thorndon, i.e. the Wellington suburb. His sense of the legal history of the treaty in New Zealand law was strong, and his sense of the history of Crown Māori relations generally clear, lacking any sense of rose tint, but also mindful of changing social mores, social meanings, and perceptions. For example, he alluded to the fact that integration or assimilation policies were seen by Pākehā policymakers right through to the 1960s as progressive or enlightening. But since then, the emphasis had been on Māori retaining a unique identity and a tribal land base. So a few excerpts from the judgment. Cooke stated, "This case is perhaps as important for the future of our country as any that has come before a New Zealand court." And he pointed out that the court could only deal with the treaty or its principles because the SOE Act included reference to them. And this is a key point here. Cooke said, "We are concerned with interpreting a far-reaching act passed by the New Zealand legislature. Its significance lies partly in its express incorporation of the principles of the treaty in this field of New Zealand domestic law." In considering the treaty itself, the court did refer to the Māori text and ka wharu's back translation of it into English. Cooke declared in ringing phrases, "The differences between the text and the shades of meaning do not matter for the purposes of this case. What matters is the spirit. This approach accords with the oral character of Māori tradition and culture. It is necessary also because the relatively sophisticated society for whose needs the State-Owned Enterprises Act has been devised could not possibly have been foreseen by those who participated in the making of the 1840 treaty. In brief, the basic terms of the bargain were that the Queen was to govern and the Māoris were to be her subjects. In return, their chieftainships and possessions were to be protected, but sales of land to the Crown could be negotiated. These aims partly conflicted. The treaty has to be seen," said Cooke, "as an embryo rather than a fully developed or integrated set of ideas." And then Cooke introduced this new word, partnership. "The treaty," he said, "signified a partnership between races, and it is in this concept that the answer to the present case had to be found." Cooke underlined the court's 2 major conclusions. First, that the principles of the Treaty of Waitangi override everything else in the State-Owned Enterprises Act. Second, that those principles require the Pākehā and Māori treaty partners to act towards each other reasonably and with the utmost good faith. Justice Richardson had this to say, "Where the focus is on the role of the Crown and the conduct of the government, that emphasis on the honour of the Crown is important. It captures the crucial point that the treaty is a positive force in the life of the nation and so in the government of the country. No less than under the settled principles of equity, as under our partnership laws, the obligation of good faith is necessarily inherent in such a basic compact as the Treaty of Waitangi." And so, in conclusion, the treaty was thenceforth to become characterised as a partnership in New Zealand law and policy making. But it is interesting to note that the principles of the treaty were in part, at least, articulated in terms of the text. The Crown exercising powers of government for the country, Māori and Pākehā, and all peoples, and iwi Māori exercising ongoing authority, in relation to their land and other taonga. This was the treaty relationship that the SOE Act had brought so forcefully into the modern era, and in so doing, the Crown's treaty obligations to preserve and return a land base to Māori became institutionalised in effect. Treaty remedies of returning land were thereby empowered. The Lands Case 1987 was therefore a far-reaching legal decision on multiple levels. I annex the full case judgment below, which is definitely worth studying. Kia ora tātou katoa.